Good evening. I'm Elizabeth Schlissel, and welcome to the Theodore Roosevelt Inn of Court Annual Installation Ceremony. This year, for the safety of our members and guests, we will have our program virtually. We look forward to a time when we will all be together again in person. I would like to thank everyone who helped make today possible, including but not limited to Judge Phoenix, Jess Bunshaft, Allison Berger, Hector Herrera, Justice Leonard Austin, and Presiding Justice Hector LaSalle. Thank you and enjoy the program.
Good evening, and thank you all for attending tonight, and my thanks to the committee for inviting me to do the invocation. What makes this country great is not that everyone thinks alike, but the diversity of its people. The vision of the American Inns of Court is a legal profession and judiciary dedicated to professionalism, ethics, civility, and excellence amongst all our people. The mission of the American Inns of Court is to inspire the legal community to advance the rule of law by achieving the highest level of professionalism through example, education, and mentoring. Our inn does it all. We are gathered today at our own desktops or laptops, or perhaps even our cell phones, with diverse members of the legal community, with the shared belief that we must treat each other with dignity and respect. In this invocation, I don't ask you to bow your heads, but to look up at what you can accomplish by working together in a civil manner. I don't ask you to close your eyes, but to keep them open, wide, to the problems that we face as a country, a county, and most importantly for our purposes in the profession of law. With your talents and insight, we can lead this close-knit community of lawyers to a better future for themselves and their community by maintaining and pursuing the goals of the American Inns of Court. As you work together on behalf of all who live in this community, may you draw strength and encouragement from one another through compassion and reason. May the pupillage groups that many of you are part of from year to year be such a tool to accomplish these goals. We should never let our political differences prevent us from working together to accomplish the goals of the Inns of Court. Remember, being a member of the majority doesn't necessarily make you right, just part of a group that thinks alike. Thank you for coming tonight, and have a wonderful evening.
All rise, hand over heart. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First, let me congratulate this fantastic new board of the Theodore Roosevelt Inns of Court. This is a fabulous lineup, with Jess Bunshaft at the helm and my associate, Michael Berger, as the treasurer. I'm very proud of him, I really am. I know great things are gonna come from the inn this year. I'm really looking forward to a fabulous year. So it's been a little while since I've been honored enough to say the toast to Domus. And as you can see, the building is open. We're all here. If you haven't been here yet, come on down. Lunch is open, the committees are happening, come on down. But this building is a symbol. It's a symbol of what the law stands for. It's a symbol of justice. It's a symbol of our professional camaraderie. It's a symbol of what we attorneys strive to be. And just like the Inns of Court in London, on which this great hall is modeled after, it's a symbol of the rule of law that is paramount to any democratic society. Each day that I walk into this building, it makes me realize how important and yet how fragile the rule of law is. For just like this building, the rule of law requires constant maintenance or it will crumble. We cannot take it for granted that the rule of law will always be here. We have to nurture it. We must care for the rule of law like we care for this home of ours. I know the Inn understands this probably better than anyone. So I ask you to lift your glasses to this wonderful new board, to the rule of law, and to Domus.
Good evening. For those of you who may not know me, I am Lois Schlissel, and it is my pleasure this evening to announce the recipients of 2 awards that the Inn presents each year: the Kathleen Beckett Memorial Award and the Honorable Gregory W. Carmen Memorial Award. But before I do that, I want to join in congratulating Jess Bunshaft as being elected as our new president. And I also want to thank Judge Phoenix for her hard work and her leadership this past year. She was installed in the midst of this pandemic, and nevertheless, she stepped up and achieved a great deal for our Inn during her presidency. So congratulations, Jess, and thank you, Judge Phoenix. Now, the Kathleen Beckett Memorial Award is an annual cash award in the amount of $1,000 presented on a rolling basis to one of our 3 law school affiliates, Hofstra, Touro, and St. John's. The award honors the memory of Professor Kathleen Beckett, who was an early leader of our Inn and a distinguished professor of law at Hofstra Law School. It recognizes, too, the important role that our students play in the Inn programs, particularly in presenting our pupillage group programs at our Inn of Court dinners. This year, we're very pleased to present the award to Hofstra Law School. Now, the Honorable Gregory W. Carmen Memorial Award was established last year in memory of another Inn of Court wonderful leader. Judge Carmen was Chief Judge of the United States Court of International Trade, and he was a former president of our Inn. The award is presented to one recent law school graduate from each of the law schools affiliated with our Inn. Each school selects one recent graduate to receive a fully paid membership in the Inn for 1 year. This year's recipients are Catherine Murata, a 2021 graduate of Hofstra Law School; Olivia Latanza, a 2020 graduate of Touro Law Center; and Nalian Scaturo, a 2021 graduate of St. John's Law School. Congratulations to each of you, and welcome to the Inn. Thank you. Enjoy the evening, everyone.
Judge LaSalle, thank you for agreeing to be the honoree and keynote speaker for the Theodore Roosevelt American Inn of Court virtual installation dinner. Unfortunately, for the 2nd year in a row, we were forced to hold our installation virtually, and therefore you weren't able to join our members in person. The Inn is a very special organization, founded on the ideals of advancing the highest levels of integrity, ethics, civility, and professionalism, as well as on defending the rule of law. Our Inn is one of the nation's oldest, with a very special membership. We've been privileged in the past to have been joined by many of your fellow judges from both the federal and the state benches, and are so very honored that you agreed to join us, albeit virtually, this evening. As a token of our gratitude to you for making the time to join us and to speak with us this evening, we'd like to present you with a gift, which we hope you will display in your chambers as a reminder of this event. And we hope that during the next coming year, you will find the time to join us for 1 or 2 of our programs, hopefully in person. Judge LaSalle, it is our pleasure to present you with this year's gift.
Thank you very much. I'd like to read the inscription, if that's okay. The American Inns of Court, Theodore Roosevelt American Inn of Court, presented to Presiding Justice Hector D. LaSalle, Appellate Division of the Supreme Court Second Department, honoree, 2021 installation ceremony October 18th, 2021. I want to thank you for this kind gesture. I can tell you, this is beautiful, by the way. It's very much appreciated. This will be in my office, and I will be a constant reminder of what I hope will be a long and continued friendship between the court and your organization. So thank you again for your kind gesture. I certainly appreciate it.
Judge Phoenix, several years ago, when the nominating committee reached out to you to ask if you would agree to accept the nomination of President-elect of our Inn, your plate was more than filled to capacity at that time. And knowing you as we do, we knew that each of your other obligations was receiving your full attention. In addition to your judicial obligations and chairing several subcommittees for We Care and other bar and community organizations, your devotion to your family and your community meant you were often called upon to provide a helping hand to so many. We knew, however, how much you care about our Inn, and that if you said yes, you would put your heart and soul into your presidency, and that the Inn would be in very good hands. Thank you for saying yes, and for all you have added to our Inns by your leadership over the past year. Despite the fact that your presidency has been fully virtual, you have done possibly more during your presidency than anyone before you. You instituted new protocols, new programs, as well as ensuring that the Inn continued to run smoothly throughout a pandemic. As a former president of this Inn, and as your friend, I am truly honored to be able to present you with this gift as a token of our gratitude for all you have done for the Theodore Roosevelt American Inn of Court. Not just this past year, but for all the years you've been a member. Congratulations. You now join the ranks of immediate past president of the Theodore Roosevelt American Inn of Court. Judge Phoenix, I am delighted to present you with this gift.
Goodness, this is absolutely stunning. Thank you so much, Marilyn.
Oh, our pleasure, Your Honor. Thank you for all you've done.
Thank you.
Good evening. 1 year ago, when I assumed the presidency of the Theodore Roosevelt American Inn of Court, I noted in my acceptance speech that the best was yet to come. And while there is still more to come and unfold, our chapter has already celebrated many successes this year. As members, we embraced central principles of the collective American Inns of Court, inclusive of civility, legal skills, mentoring, ethics, and professionalism. We have strengthened our committees, our membership, and our outreach, and we have been passionate about mentoring and guiding our law students and attracting younger members. Our scholarship incentives and mentoring programs have been demonstrative of these efforts. The members presented stellar programming all year long, inclusive of diversity and other timely legal topics. I particularly enjoyed our new Insights on the Law programming, which featured fireside chats and memoirs from the federal bench. Our audience was uniquely comprised of members, non-member attorneys, and community leaders. These are among the many Inn experiences that have claimed my heart and mind this year. I thank God, my supportive family, my sponsor, and our past president, Judge Lawrence Brennan, fellow officers Jess Bunshaft, Matthew Flanagan, and Michael Berger for all of their hard work, our staff, Hector Herrera and Donna Gerdick, and an amazing and dedicated executive board who would be a true blessing to any president. I thank our esteemed membership for a wonderful year. I was so fortunate to interact and mingle with such an impressive group comprised of bright and intellectually curious legal professionals who set the benchmark for excellence. Congratulations to our new officers and board members. Jess Bunshaft, I know without a doubt that you will be a marvelous president. I congratulate you as you assume the leadership of our illustrious chapter. I will now take my seat, having had the privilege and the honor to serve as your president. Thank you.
Thank you very much. I appreciate the invitation to introduce our presiding justice, the Honorable Hector LaSalle. I've got to tell you that many times I've been asked to introduce our guest speakers at our annual dinners, and it's always an honor to be able to do that. However, this particular time, it's a special honor for me to be able to introduce Presiding Justice LaSalle. Let me explain why. We are a court that is the busiest appellate court in the United States. We handle well over 4,000 appeals, and we have more than half really, the population of the state of New York. We have 22 judges who are eligible to be serving in our court. However, through the magic of our governmental system, rarely do we hit that number. Presently, we are at 19 and soon to be 17. Hopefully that will change, but it takes a special kind of leadership to be able to handle the vicissitudes of 22 or even 19 alpha personalities who are competent in the law, competent and confident in what they're talking about, and be able to create one voice out of that mass of legal talent. And I'm honored really to be a part of that. So Justice LaSalle came to the appellate division in 2014. So he's been with us for 7 years already. It probably has been the happiest 3 weeks of his life, but that's because of the workload and the necessities of our efforts that are involved. But let me tell you a little bit about him and tell you why it is so special to be able to introduce him and give him the floor to hear his thoughts tonight as our honored guest. First of all, Justice LaSalle graduated from Penn State University with a major in political science. He got his JD from the University of Michigan, although both in the Big Ten or now Big 11, do not talk about Penn State to him. It's Michigan's or nothing. He did a stint as an assistant attorney general. He did a stint as an associate at Ruskin Moscow, but most of his career was spent in the Suffolk District Attorney's Office as an ADA, and then rising to Deputy Bureau Chief of the Special Investigations Unit, as well as the head of the Anti-Gangs Unit. He has excelled in everything that he has done professionally before he came to the court. He was elected in 2008 to the Supreme Court. In 2012, he was appointed to the appellate term, where he served with distinction for 3 years. And then, as I said, in 2014, he was appointed by Governor Cuomo to be an associate justice of the court. During that time, he demonstrated his intellect, his collegiality, his willingness to work with his various other colleagues to create an atmosphere of production and legal scholarship. He has been incredibly strong, both as a junior member of the court and now as the senior and leader of our court. That is an important distinction, because seniority means a great deal to all of us, is a way of functioning and surviving in a very, very pressured legal atmosphere. So since May 25 of this year, Presiding Justice LaSalle has demonstrated an eagerness to innovate, a desire to support every single member of the court, judicial and non-judicial, which is so very important. He has inherited a very difficult situation with regard to our being shorthanded as to the number of judges, but also shorthanded in our various departments. Hiring freezes, budgetary issues have all reared their ugly heads and made it that much more difficult for all of the courts to really operate at maximal ability. But that being said, in PJ LaSalle, we have somebody who's prepared and focused, respectful of the bench, consistent, clear, and up to date with regard to what he wants to accomplish. What he wants to accomplish is give every single lawyer and person who comes before our court an opportunity to be heard, an opportunity to explain their positions, and to get their decisions as quickly as possible. But that's not all. Obviously, if you win the case and you get a decision that says affirmed, you're happy, and rationale sort of falls by the wayside. If you lose the case, that's really where it becomes important, because that's where we need to explain why you lost, why the system is working, even when there is a reversal or a modification. So usually the complaint that I heard before I became a member of the court was, why is it you always give us so little to work on as to the basis of your decision? And the answer is because sometimes we just don't have the time to really write as much as we'd like. Already with his stamp on it, we are producing work that is far more detailed, far more helpful to the bench and bar in terms of the jurisprudence with which we operate and the theories under which we decide our cases. I have to tell you that we've gone through a period in my short time on the court, although some would argue long, it's 13 years now. I have served under now 4 presiding justices and an acting presiding justice, Justice Mastro, twice. As I'm sure it comes as no surprise to you, each presiding justice brings his or her own brand of approach to each and every case and each and every matter that comes to the court. In his short time, I would say that Presiding Justice LaSalle has given us a focused path to the future. He has advocated for more staff. He has advocated for more judges, as have all, by the way. But he is energetic, not to say anybody wasn't. He is active. He is focused. His view on the rule of law is positive. I am happy to and honored and privileged to be able to introduce Presiding Justice Hector LaSalle as our honored guest this year. The only regret I have is that we all couldn't be together in person, and God willing, very soon, we will all have that opportunity. I am pleased and honored to introduce to you the Honorable Hector D. LaSalle, Presiding Justice of the Appellate Division, 2nd Department.
Good evening. My name is Hector LaSalle, and I'm the Presiding Justice of the Appellate Division, 2nd Department. I'd like to take a moment to thank the Theodore Roosevelt American Inns of Court for allowing me to address you this evening and giving his keynote address. This evening I'm going to be discussing the issue of preservation in criminal matters. I'm going to just give a brief overview of the subject matter. I hope you'll find it helpful, particularly for those of you who are active in our criminal courts. The purpose. The salutary goal of the well-established preservation requirement is to avoid the need for an appeal and provide the opportunity for cure before a verdict is reached and a cure is no longer possible. That was stated in People v. Jackson in 2017, quoting People v. Gray, which is a 1995 case. This requirement prevents a party from sitting idly by while error is committed, thereby allowing the error to pass into the record uncured and yet claim the error on appeal. Makes perfect sense. The preservation rule generally requires the parties to present their arguments on the issue in the trial court, creating a record for appellate review. The preservation rule in criminal cases is codified in the CPL section 470.05 subdivision 2, which sets forth the appropriate procedure for preserving an error of law for appellate review. And the one thing about that particular statute, it's pretty comprehensive and specifically lays out what needs to be done in order to maintain and ensure preservation. The statute requires that a protest must be registered at the time of such ruling or instruction, or at any subsequent time when the court has had an opportunity of effectively changing same. Good example is People v. Cantave. After a hearing pursuant to the Sandoval rule, the Supreme Court ruled that the people would be permitted to cross-examine the defendant about the underlying facts of a rape conviction that was then on direct appeal. Defendant did not testify. After the defense rested, defense counsel asked the court to reconsider its Sandoval ruling, objecting that an appeal of the rape conviction was pending, and therefore cross-examination about the conviction and its underlying facts would violate the defendant's constitutional privilege against self-incrimination. But the court adhered to its ruling. The Court of Appeals held that this objection was timely because it was lodged at the time when the court had the opportunity of effectively changing its ruling, since neither side had yet presented closing remarks and the jury had not yet commenced deliberations. In contrast, the Court of Appeals has held that a motion for a mistrial that is made after the completion of a prosecutor's summation is insufficient to preserve a contention that the prosecutor committed misconduct during the summation. I think it's important to note, and I know what some of the practitioners watchers may think, well, Judge LaSalle, the trial judge told me, or told us, that we couldn't object during the closing. He or she wouldn't hear of it, and banned us or barred us from doing that. I think what's incredibly important to note is that when you have specific instructions from a court that may, in your opinion, preclude your ability to properly preserve an issue, that you discuss that issue with the court diplomatically and respectfully on the record and explain the need to make a record and timely specify your objection. Hopefully, you will get a directive from the court that will meet the obligations of the specificity obligations and timeliness obligations of the preservation rule, while at the same time adhering to the judge's requests. If you're barred from speaking, that might create appellate issues of themselves. I should also note before I go any further that what I'm discussing is my view of the law. By no means do I speak for the other 18 members of the appellate division. I certainly do not speak for any of the judges in our appellate divisions throughout the state. This is just my view of the law. Specificity. Counsel's objections must be sufficiently specific in order to preserve an issue for appellate review. Objections that are general in nature and unelaborated, such as simply saying objection, are usually inadequate to preserve a specific issue for appellate review. This goes back to a 2019 case, People v. Britt, which was also referencing a case from 1994, People v. DeVeccia, 84 NY2D 879. I think that's an important site for you to have. I mention this again for those of you who are practicing lawyers. You may be before a judge who doesn't want to hear what he or she may refer to as speaking objections. They may say, objections, I know what you're talking about. I would urge you again, respectfully, to adhere to what the court wants to do, but to perhaps speak with the judge about the importance of laying out what specifically you're objecting to. Oftentimes, those of you who are practitioners know, there are multiple reasons for an objection. It could be to the form of the question, it could be to the substance of the information that could potentially be elicited. Absent specificity, there is no assurance that the appellate court will review what your issue was. And it's dangerous for lower court judges to try to assume they know exactly what the objection was. Now, having tried cases in the trial court and sat in the trial court, I'm aware of why many judges, trial judges, have this rule of being trying to limit objections. I know it may be difficult to believe that there are attorneys out there who give speaking objections in an effort to persuade the fact finder or to make a statement unrelated to the matter at hand. And it's common sense, and I think when judges try to limit these objections, they're doing so in good faith. But there has to be a balance to assure that the trial lawyer has an opportunity to specifically lay out for the trial judge and potentially for the appellate court what the issue is that they're objecting to. For example, during a trial at the close of the people's case, it is not enough for defense counsel to move to dismiss for quote-unquote insufficient evidence or for failure to make a prima facie case. Counsel's argument must be specifically directed at the alleged error. This happens frequently. In my experience, there are attorneys who simply say, it's almost a rote answer, but you must lay out specifically where the failure lies in PFC or when you're making an insufficient evidence argument. For example, counsel should specifically argue that the identification evidence was insufficient to support the conviction, that testimony of prosecution witnesses was incredible as a matter of law, that DNA and other expert testimony was insufficient to support the conviction, or that a specific element of a charged crime was not proven beyond a reasonable doubt. Even where this is important to note, even where a ground for an objection is specified, if the ground is not the same as the one later raised on appeal, the appellate contention is unpreserved for appellate review. Again, demonstrating the need for specificity, right? It's critically important. So again, if you object to a question because of its form, compound question, for example, but it was a question that elicited testimony that was out of adherence to a prior in limine application. If you don't specifically make that objection and you simply object on the form, the appellate court could indicate that failed to give the specificity required to ensure that preservation was done. Now, this is going to make up probably a large part of my talk today, and those are exceptions to the preservation rule. And the one that many lawyers try to rely upon, admittedly, when an issue wasn't preserved, is referencing the appellate division's interest of justice jurisdiction. That's under CPL section 470.15, and it gives the appellate division the authority to reverse a modified judgment, sentence, or order of a criminal court as a matter of discretion in the interest of justice where an error or defect occurred, which error or defect was not duly protested at trial or prescribed in subdivision 2 of section 470.05 so as to present a question of law. To my friends who practice criminal defense, it is, in my opinion, folly and bordering on potential malpractice to assume that the appellate division will always exercise its interest of justice jurisdiction to reach an unpreserved contention. The court that I serve in has often declined to exercise its interest of justice jurisdiction to reach unpreserved contentions. We can talk about People v. Cunningham, People v. Morales, People v. Whitaker, People v. Craig, People v. Cruz, and I can go on and on and on. It's important to note that the Court of Appeals does not have interest of jurisdiction, as many of you know. Its jurisdiction is generally limited to review questions of law. It's important to note that. Thus, unless another exception to the preservation rule applies, the Court of Appeals has no power to review an unpreserved issue, even when the appellate division exercises its interest of justice jurisdiction to review an unpreserved issue. It's also important to note The Court of Appeals is not bound by the intermediate court's characterization of its own order and must determine for itself whether its reversal of the judgment of conviction presents an error of law for its review. Thus, the issue of preservation is often extensively discussed in Court of Appeals decisions. So again, even if we reach it in the interest of justice, in the event you want to be able to get to the Court of Appeals on that issue, absent an error of law, the Court of Appeals can't get it. So again, to those lawyers who think that, don't worry, the appellate division will get there, I think you're playing Russian roulette. Don't think it's a good idea to practice that way, and I would suggest you err on the side of preservation whenever you can. Another exception to the preservation rule is one that many of you are familiar with, and that's a mode of proceedings error. It's obvious, and many of you know, that a defendant in a criminal case cannot waive or even consent to waive error that would affect the organization of the court or the mode of proceedings prescribed by law. Now, not every procedural misstep in a criminal case is a mode of proceedings error. The error must go to the essential validity of the process and be so fundamental that the entire trial is irreparably tainted. But there are examples that many of you are familiar with: shifting the burden of proof from the prosecution to defense, the delegation of the trial judge's function to his or her law secretary, a trial before fewer than 12 jurors in a criminal matter, a trial before a court not of competent jurisdiction, and a violation of the right to counsel or violation of the ban on double jeopardy. The failure to keep a jury sequestered, and a failure to provide defense counsel with meaningful notice of the precise contents of a substantive jury note in accordance with 310.30. That goes back to a Rama seminal case and was referenced again in People v. Parker. So, as many of you know, a mode of proceedings error does not have to be preserved. And it is an exception to the preservation rule. Another exception that doesn't have to be raised is the weight of evidence review. Upon defendant's request, the appellate division must conduct a weight of the evidence review. A defendant will be given one appellate review of adverse factual findings. Accordingly, I should note there is no preservation required for weight of the evidence review. The appellate division's special power requires the court to affirmatively review the record, independently assess all proof, substitute its own credibility determinations for those made by the jury in an appropriate case, to determine whether the verdict was factually correct, and acquit a defendant if the court is not convinced that the jury was justified in finding that guilt was proven beyond a reasonable doubt. It permits an intermediate court to serve, in effect, as a second jury. Necessarily, in conducting its weight of the evidence review, a court must consider the elements of the crime, for even if the prosecution's witnesses were credible, their testimony must prove the elements of the crime beyond a reasonable doubt. In contrast to the weight of the evidence review, when a court is determining whether a verdict was based on legally sufficient evidence, it must view the evidence in light most favorable to the people, grant the people all reasonable evidentiary inferences, and determine only whether there is any valid line of reasoning and permissible inferences that could lead a rational person to conclude that every element of the charged crimes has been proven beyond a reasonable doubt. That's discussed at length in People v. Gordon. Since the weight of the evidence standard is easier for defendant to meet than the legal sufficiency standard, and since weight of the evidence review is not subject to the preservation rule, while a legal sufficiency argument is, it is generally not advisable for defense counsel to spend much, if any time, arguing to the appellate division that a legal sufficiency argument is preserved or that the evidence was legally insufficient. It is better to focus on the weight of the evidence argument. Note that a defendant does not lose the right to appeal a legal sufficiency argument to the Court of Appeals by failing to raise it at the appellate division. The Court of Appeals may consider any question of law regardless of whether such question was raised, considered, or determined upon appeal to the intermediate appellate court. So while you don't have to do that, I would nonetheless recommend that you make all of your arguments, okay? So I would lay out that you lay out your legal sufficiency argument in your brief, and also your weight of the evidence argument. Obviously, I shouldn't say obviously, you may choose to spend more time on weight of the evidence. But again, remember that you got to think long-term, not just what could happen in the appellate court or the intermediate appellate court, pardon me, but for what could potentially happen in the Court of Appeals. And your case may ultimately get there. And you want to keep every door open for your client, obviously. Another exception is ineffective assistance of counsel. This makes sense, right? A claim of ineffective assistance of counsel need not be preserved for appellate review. That makes complete sense, right? It's logical. Is a lawyer really going to step up and say, I've been incompetent or I've been ineffective during this trial? Probably not. Accordingly, we could not expect that to be preserved. Another issue which deals with jurisdiction is the facially insufficient accusatory instrument. The failure of an accusatory instrument to contain non-hearsay allegations, which, if true, would establish every element of the offense charge, is a jurisdictional defect that is not waivable by defendant's failure to raise the issue until his or her appeal. There is a narrow exception to the preservation rule permitting appellate review when a sentence's illegality is readily discernible from the trial record, pardon me. Not all claims arise during a sentencing proceeding fall within the exception. For example, challenges to the court's procedures, evidentiary disputes, and claims that rely on documents or facts not otherwise developed in the record must be preserved by timely objection in the sentencing court. So when we talk about what type of error, defendant is sentenced to 27 years on a manslaughter 1 conviction, the maximum is 25. That doesn't have to be preserved. The appellate division can review that. It's just a simple example. Another exception. If the defendant's guilty plea allocution clearly casts significant doubt upon the defendant's guilt or otherwise calls into question the voluntariness of the plea, in that rare case where the defendant's recitation of the facts underlying the crime pleaded to clearly cast significant doubt upon the defendant's guilt or otherwise calls into question the voluntariness of the plea, the trial court has a duty to inquire further to ensure that the defendant's guilty plea is knowing and voluntary. Where the court fails in this duty and accepts the plea without further inquiry, the defendant may challenge the sufficiency of the allocution on direct appeal, notwithstanding that a formal post-allocution motion was not made. In such cases, the court's attention should have been instantly drawn to the problem, and the salutary purpose of the preservation rule is arguably not jeopardized. This has been the rule in our state for many, many years. I think the seminal case on this particular issue is People v. Lopez, and that goes back to 1988. So again, an improper allocution is an exception. Another exception, and I have two left, but this is the 8th exception, is the error is clear from the face of the record and occurred under circumstances in which it would be practically impossible for the defendant to object. That's an interesting one. A case that discusses this at length, and I'm going to give you the site, is People v. Louree, L-O-U-R-E-E, 8, New York 3D 541 from 2007. In that case, the defendant had pled guilty in exchange for a promised sentence of 1 or 2 years unless he failed to comply with certain conditions, in which case he was informed that he could receive a higher sentence up to 7 years. The defendant failed to comply with the conditions, and at the conclusion of a sentencing proceeding, the court pronounced that he was sentenced to 7 years imprisonment, followed by 5 years post-release supervision. On appeal, the defendant contended that his plea was not knowing, intelligently, and voluntarily entered because he was not informed at the time of the plea that he would be subject to post-release supervision if he failed to comply with the conditions. The Court of Appeals concluded that this contention did not require preservation. They stated that the court could not shut its eyes to the actual or practical unavailability of either a motion to withdraw the plea under 220.60 subparagraph 3 of the CPL, or a motion to vacate the judgment of a conviction under 440.10. If the trial judge does not mention post-release at the allocution, a defendant can hardly be expected to move to withdraw his plea on a ground of which he has no knowledge. But if the trial court informs the defendant of post-release supervision during the course of sentencing, A defendant may no longer move to withdraw the plea since a motion may only be made under CPL 220.60 subparagraph 3 at any time before the imposition of sentence. Finally, the omission at issue is clear from the face of the record and therefore not properly raised in a CPL Article 440 motion. So what's important to note in that limited scenario is, once again, how could the defendant be expected to object to something he or she has no knowledge of? Now, People v. Lurie does not stand for the proposition that any attack on the voluntariness of a plea is exempt from the preservation rule. If a defect in a plea allocution is clear on the face of the record and implicates due process, the defendant nonetheless must preserve his or her claim that the defect made the plea involuntary unless the defendant had no practical ability to do so. And that's what it comes down to. Again, knowledge, information before the defendant. In People v. in People v. Murray, 15 NY 3D 725 from 2010, the defendant contended that his plea was involuntary because he was not informed of the post-release supervision component of his sentence at the time of plea. But the Court of Appeals concluded that this contention required preservation because in that case, the defendant was advised of what the sentence would be, including its term of post-release supervision at the outset of the sentencing proceeding. The court stated that because the defendant could have sought relief from the sentencing court in advance of the sentence's imposition, Lurie's rationale for dispensing with the preservation requirement is not presently applicable. So again, it came down to information before the defendant. And then the last exception is excessive sentence. CPL section 470.15, subparagraph 6, subparagraph B provides that the appellate division may modify a sentence as a matter of discretion in the interest of justice when the sentence, though legal, is unduly harsh or severe. Thus, a claim that a sentence is excessive by definition adjusts to the appellate division's interest of justice jurisdiction and does not need to be preserved as a matter of law. So those are our exceptions. So in conclusion, when discussing issues of preservation, I think it's entirely important and critical that the bar remain vigilant in objecting with specificity issues that it believes are error in matters before a criminal trial court. There are tactical reasons why decisions are made. However, failure to preserve will rarely inure to your client's benefit. It's an issue that I don't believe it's discussed enough. I think it's something that's critically important. It is a big distinction between some of the best trial lawyers in our department and some who are aspiring to get to that level. The ability to concisely yet thoroughly preserve issues for appellate review. So I want to thank you again for taking the time to hear me speak on this important topic. I look forward to having the opportunity to speak with you all again. I'm hoping that when the public health crisis abates, we'll have the opportunity to meet in person. So again, thank you for the honor of giving me the honor to address you this evening, and I wish you a very wonderful night. Thank you. Good evening. And at this time, I'm going to administer the oath of office to Mr. Jess Bunshaft. Mr. Bunshaft, if you raise your right hand. Sir, do you solemnly swear or affirm that you will uphold the Constitution of the United States of America, the Constitution of the State of New York, the bylaws of the American Inns of Court, and the bylaws of the Theodore Roosevelt American Inn of Court, and moreover, will you faithfully discharge the duties of the office of President of the Theodore Roosevelt American Inn of Court to which you have been elected, and do so with the utmost commitment, vigor, and fidelity?
I will.
Congratulations, sir.
Thank you very much, Judge.
Good evening again, ladies and gentlemen. At this time, we'll be swearing in the board members. Would you please all raise your right hand? Do you solemnly swear or affirm that you will uphold the Constitution of the United States of America, the Constitution of the State of New York, the bylaws of the American Inns of Court, and the bylaws of the Theodore Roosevelt American Inn of Court, and that you will faithfully discharge your duties as officers, executive board members, and as members of the board of directors?
I will.
I now declare you duly sworn to undertake your duties and responsibilities as charged. Congratulations.
Distinguished members of the Theodore Roosevelt American Inn of Court, I am delighted to present this banner, and it is a symbol of all of the scholarly endeavors and professional endeavors that we have invested in as members. At this time, I welcome our new president, Jess Bunshaft, to share in this moment. And at this time, I will hear from Jess.
Well, thank you, Judge. It's a pleasure to accept the new banner on behalf of the Inn and its membership. I'm sure we'll make great use of it in the years to come. Thank you.
You're very welcome.
Good evening, fellow officers, board members, members of the Theodore Roosevelt Inn of Court, and guests joining us tonight. I'm honored that we are also joined tonight by Justice Hector LaSalle, recently appointed presiding justice of the busiest appellate court in the state of New York, our own Appellate Division, 2nd Department. Welcome, Justice LaSalle, and thank you for agreeing to be our keynote speaker. I'd also like to thank Justice Austin for making the arrangements to have such a distinguished speaker join us. I'd like to thank our dinner committee. We may have no dinner this year due to circumstances beyond our control, but they still had a lot of work to do. So Liz Schlissel, Allison Berger, thank you very much. And all of our presenters and the rest of the folks who, as usual, made a successful team effort on behalf of our Inn. My name is Jess Bunshaft. I'm president of our Inn for the coming program year. I first joined the Inn as a student member around 1989. After graduating law school, I lost that student status in 1991. But I soon was invited to come back in 1992 and have been a member of the Inn since then. I've served on the board for I don't know how many years at this point. I've lost track, quite honestly. I've been in many presentations and together with colleagues for whom I'll always be thankful, we've accomplished a lot. I'd be quite remiss if I didn't thank the person who's been along for most of those 30-odd years. Well, 26 plus of them, my husband Mark, who is here, but was clear with me that he does not need to be on camera. He's had many evenings where he lost me to a board meeting, a pupillage group, or general Inn meeting. As with everything in life, I'm grateful for his support. He makes so much possible. Thank you, hon. Now, as we all know, we're living in challenging times. We've seen too many get sick and too many die of a terrible virus. But we, as citizens of this nation, officers of the court, and members of this Inn, persevere. We move forward, continuing to seek justice and answer the call to make our system of justice fairer for all with each passing year. With that drive in mind, our immediate past president, Judge Andrea Phoenix, and the officers and members of the board managed to complete a successful program year, even if we had to bring it to all of you this way, online. My hope when I became president-elect of the Inn was that we'd have the pandemic in the rearview mirror by the time I took my oath of office as president. My hope and vision for this mile marker in our progress was that we'd use today's event as a return to in-person meetings so we can enjoy each other's company and the social interactions that, as much as our educational programs, define the Theodore Roosevelt American Inn of Court. Unfortunately, as we looked at the statistics for our area, I believed, and the board agreed, that we needed to err on the side of caution. As much as we wanted to get together with all of you, our greater duty was to protect the health of our members. So for one more year, we are going to do this online. Soon enough, we'll be together again. In fact, I'll continue to hope that this program year allows us to return to in-person, or at least hybrid, meetings. For now, however, let's be thankful for the good health of each other and all those we care about. We're all part of the Inn because we believe in its mission. The American Inns of Court are dedicated to the ongoing improvement of skills, professionalism, and ethics of the bench and the bar. In our honorable profession that is the foundation of our republic, We've dedicated ourselves to the best, most noble goals of our profession. To that end, we will continue to pursue programs that always drive us to consider how we can build our skills, professionalism, and ethics. At the same time, we are, as ever, focused on making our programs interesting. Looking forward to this program year, we have plans for diverse topics, among them criminal justice reform, immigration, employment issues, and a program on the Supreme Court under Chief Justice Roberts. There will be plenty to engage our minds and continue our professional growth. We also will be continuing our efforts to engage with our law school partners, grow our mentoring program, and build connections for students and newer lawyers with senior practitioners and members of the bench. This proud organization brings out our best, forms bonds that endure, and gives us reason to be proud. In the year to come, as we continue through these strange and challenging times, I pledge to you that I will do my best so that with your help, your pride in the Theodore Roosevelt American Inn of Court will continue to grow, and you will continue to be happy that you are part of this special organization. Thank you.